Good morning, ladies and gentlemen. This Tuesday, the 5th of November, Arkansas Oil and Gas Commission, special hearing for the royalty on lithium. We're a division of Arkansas E&E, and I turn it over to our director.
Once again, there's not as many folks here today, but silence your phones so we don't have any ringing going on. And as we happened yesterday, that goes for you, Chairman Langley. So. Okay, thank you.
All right, we are back on the record. Continuation of co-applicants' request for lithium royalty in docket number 050-2024-09. Mr. Daly, we were at the cusp of your rebuttal. I'm not certain, sir, how you want to proceed with that, if it's going to be you or Mr. Honey or a combination thereof.
It will be me, Judge Moulton. I have only 2 witnesses and only about 4 questions for each of them, so it'll be quick.
All right, sorry. We did have something passed out before we did go on the record. It's Exhibit L, says Lithium Royalty AOGC hearing November 5th, 2024. You want to have that introduced into the record? Yes,
right. Please. Right. That is the PowerPoint that will accompany this little rebuttal presentation.
Right. We'll go ahead. Your motion to admit into evidence Exhibit L is granted. Does Mr. Perkins have a copy of it? All right. Mr. Perkins, you can have my copy.
Yeah.
Mr. Daly does, okay, I was going to say, does the court reporter have a copy of it? You do. All right. All right, Mr. Daly, please proceed.
All right. Call Dr. Andy Robinson. You'll have to really lean into that microphone.
Okay, I'll try my best.
State your...
Mr. Daly, can I ask, Dr. Robinson, were you sworn in?
No, he was not.
All right. Would you be so kind as to raise your right hand? Do you swear or affirm the testimony about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you, sir.
Please state your name.
My name is Andy Robinson.
You need to really talk into the mic.
Okay, will do.
Yeah. And how are you employed, Dr. Robinson?
So I'm the President and Chief Operating Officer of Standard Lithium.
Were you present in the hearing room yesterday when the definitive studies of lithium extraction that were published by your company occurred?
I was, yes.
Would you explain the current relevance of those studies?
Yeah, I think it might be helpful for me to just sort of talk a little bit about what those studies are intended to do. We are a Canadian-listed, publicly traded company, and as such, and I'm talking about Standard Lithium in isolation here, and as such, we are subject to certain regulatory oversight from a regulator in Canada. That means that when we wish to present the progress of our projects to existing or potential investors, we have to provide technical disclosure of the state of where our projects are at. So that relates to information under the ground, so the resource potential. It relates to the processes that we will use to process that resource. And it also talks to the economics of doing that. The studies, as they're called, the preliminary feasibility study or the definitive feasibility study, are so effectively then reports of technical disclosure to the investing public. They are a snapshot in time of the progress of a project, and we do not use them for making investment decisions. They are a summary of studies completed to date, put in a format that is digestible by the investing public, but they are not what we use to make an investment decision. And so, for example, I think the economics that are presented in the studies are used as an evidence of, let's say, the real economics that we would use to make an investing decision. In actual fact, there are many things which have to happen to allow a project to be financed. And so if we take an example, the Southwest Arkansas project, we've entered into a partnership with Equinor on that project. And since that partnership was formed, we have redesigned the project. We are contemplating it in multiple phases of development. We have changed the flow sheet that processed the brine. And we've also changed the final product that we're going to make. We've moved from a hydroxide product through to a carbonate product. What that means is that the PFS that's been talked about in these hearings was correct at the time that it was put in place. It used the understanding of the project at that time, and it also used at that time a forward view of the lithium pricing. And I think some of the testimony that was given yesterday by experts in that field showed that current lithium prices and future lithium prices are quite different from what was presented in those definitive feasibility and preliminary feasibility studies. And so as we move forward, there are several things that we have to do to get a project actually financed and built. If we think about the Southwest Arkansas project, again, as an example, we have to complete offtake agreements. Offtake agreements are basically forward sales contracts, which exist for many, many years. We have to negotiate those with potential customers. We then effectively have to get project debt on the project, and that's effectively a $1 billion mortgage that we have to take against that project. And the people who are going to hopefully lend us the money for that, they will test the economics of the project at the very lowest level that they think is reasonable to expect. And so when we think about the economics of a project, for us to get the money to finance and build that, the project will get tested at the very lowest level assumptions for what the product that we sell we can expect to receive. And so that means that as we move through the next year to year and a half of that particular project, the likelihood of that project becoming financed and becoming real are going to get tested at what I would assume are quite pessimistic forward-looking prices for lithium chemicals in the market. And so that just speaks to a lot of the additional complexity of the project economics for us to be able to negotiate and hopefully successfully sign any of those things, whether it's the offtake contracts or the project debt, that $1 billion mortgage that needs to go against it. The royalty scheme, the fiscal regime has to be agreed and in place for us to be able to sign any of those agreements in the future. So again, I just want to kind of highlight the difference between those public disclosure documents and the realities of financing one of these very expensive, very capital-intensive projects. One of the other points I would just like to make is that when we think about pricing for the construction of one of these projects, no such project exists on the planet right now. These are first of their kind. So I can't ask an engineering or a designer or a contractor to build me the same as what's been built before. These are the very first ones on the planet. And so it speaks again to that uncertainty and risk with capital estimates as we move through this design process. I think one of the other things that we've also seen since the decline in lithium price, since those reports were published, has been a greatly increased capital cost. So we've seen lithium projects in general and estimates on our projects significantly escalate in terms of the cost. And so we're looking at a world, since those reports were published, of both declining end product prices and rapidly increasing costs to construct and operate the plants. And so again, it speaks to the complexity of financing and the economics of these projects. It's not just a simple snapshot in time. These are long, difficult, high risk and expensive projects to execute. However, we also believe, and I think that point has been made clearly, we believe that we can make a profit from building these projects if done correctly, conservatively, etc. So that's why we're still here. That's why we spent hundreds of millions of dollars to date getting these projects to where they are. We still believe that these projects have a future in the state of Arkansas.
Let me change the subject, Dr. Robinson. There was a discussion yesterday about the option contract that exists between Standard Lithium and Tetra Technologies. Would you explain what the recurring payment to Tetra that is in that contract stands for?
Yeah, no. When we first decided we wanted to be in the Smackover Formation in Arkansas, that was during early 2017 when we started our work here, we realized it was going to be difficult and expensive to put a large lease position in place as soon as we needed it to. We were very fortunate that Tetra happened to have a series of leases from some of their previous activities in the region. That activity of collating, negotiating, putting in place a very large land package of leases, maintaining the payments on those leases for a couple of decades, in fact, and having them in such a form that they were potentially unitizable was obviously very attractive to us. And so the royalty that we agreed there, it's called a royalty, was a commercial agreement that, as we looked at, it was to compensate Tetra for all of that work that they had done for many, many years previously, the costs that they had incurred, and the fact that we were able to sort of step into the Smackover Formation in Arkansas with a ready assemblage of leases to start developing a project. So we were paying for that historical work. I think it's also worth bearing in mind that when we looked at that package and we thought about the scale of that commercial agreement, we also very, very firmly took into account the previous rulings that the commission had put in place on other royalties. And we made an assumption at the time that future royalties were likely to be very similar in the order of magnitude to what had been previously ruled by the commission. And that formed part of our thinking at the time.
So in summary, you purchased an existing lease package rather than attempting to go out and buy leases from landowners.
That's correct. And in the mining world, that's a very common occurrence. Yeah.
Let's put the next slide up, if we can. Dr. Robinson, looking again at the USGS lithium concentration map, and focusing on the lower middle rectangle, which contains the dots. Am I correct that the redder the dot, the higher the either calculated or measured concentration?
I think that is correct, Tom. Yeah. Yeah.
And there are a number of rather red dots across the line in Texas, are they not?
There are indeed.
Now, here's my question, because I was confused by this yesterday. Does the density of the dots refer to the quality of the resource, or is there simply a dot for every test well?
Yeah, I think my quick review suggests that the density of the dots is more a function of availability of existing sampling locations and the fact that there is obviously a large brine industry present in Arkansas currently. I think when we think about the quality of the resource, I think we're in the public record saying that we've been doing a lot of work in East Texas in the Smackover Formation. We see lithium concentrations in Arkansas, which are very consistent with what is shown in this USGS report. What we have seen in East Texas, and we have reported, is that the quality of the resource is superior to what we have here in Arkansas. And so as we move westwards in the Smackover Formation into East Texas, the rock properties remain effectively the same. So porosity, permeability, et cetera, in our experience, in the wells that we have drilled, remains effectively the same as that which we observe in Arkansas. But the quality of the brine, the concentration of the lithium increases significantly. And so when we think about, and again, I can only speak to the projects that we're working on as Standard Lithium, with or without partnership of Equinor, as we move from where we are right now in Union County on the projects that we're working, we have an average grade of, and forgive me if I'm spitballing a little bit on numbers, but approximately 200 milligrams per liter lithium in and around this county just here in the areas that we work. When we go to Southwest Arkansas and to sort of the Lafayette County area, we see 400 to 500 milligrams per liter lithium in that area that we're working. I can't speak for other parties. And then as we move into Texas, we've observed and reported lithium concentrations of between 600 to over 800 milligrams per liter lithium. And so in our mind, that is a significantly superior resource present across the state line in Texas. So I just wanted to make that clear, that I think some of the conversation yesterday tended to suggest that Arkansas was the only game in town, so to speak. And in our experience, that's not correct. We have observed superior brine quality in East Texas in the Smackover Formation.
Do you also have leases in Texas?
Yeah, we've been working actively in East Texas for several years now. We have assembled, as of our last sort of internal recorded date, the end of the quarter, which would be 30th of September, we've signed several hundred, well, many hundreds of leases in East Texas. Of those leases, every single one contains a royalty provision, which is on a fixed dollar per acre per year basis. Because of competition antitrust considerations, I wish I could, but I can't get into the details of what the actual dollar number is. But what I am prepared to say is that it was guided by existing royalties that have been established in Arkansas and is very similar to what is being presented by the combined group at this hearing.
Pass the witness.
Thank you, Mr. Daly. Mr. Hickey?
I don't think I have any questions for this witness. Thank you.
Thank you. Mr. Stover? Mr. Perkins?
No questions.
Mr. Pilkington? Commissioners?
Pass this out. Who made this?
Ms. Palomino made it.
I want to read something on it. On the bottom of this map, right here, it says lithium concentration shown for brine from the Smackover Formation and other geology units in southern Arkansas and the Gulf Coast region. 3 lithium concentration, 500 milligram liter from southern Arkansas are shown for reference, but was not used for summary statistics or modeling. Can somebody tell me why we didn't use them good numbers?
That actually, Commissioner Langley, that was Mr. Perkins' exhibit.
Okay.
I just put it up on the board because I wanted to clarify that the number of dots has nothing to do with measured concentration.
I would just curious why them numbers
Mr.
weren't
Perkins might know
correlated
the
in.
answer.
I'm happy to speak to it, to be honest. So the data that they used in that report, for the most part, they're existing data from the USGS produced water database. Those are of public record. Anyone can observe those. We plotted those data back in 2016 and 2017 when we were making the decision to come here. When you look at the distribution, there are certain trends that emerge in the Smackover throughout southern Arkansas, and there are a handful of analyses which are highly anomalous, I would say. So you see an area where, for example, the lithium concentration is mostly like 110, and all of a sudden there's one analysis which is 1,700. And so when we looked at those data several years ago, we made the conclusion that was likely just, and the data are typically from the 1960s, 1970s, the ones that are used. We made the conclusion that those are likely analytical errors. They don't fit the rest of the data. So that's why there's a very small number of data points. I think that's also why they included, but I'm guessing there. So please take that with a pinch of salt, right? Yeah.
Any other commissioners? Commissioner Wilson?
There was one last page to your exhibit in, will Dr. Robinson be addressing it? It was, it says South Arkansas Minerals and it's Exhibit A, Lease 1, Article 3 was the last page of your handout.
I think Remy Loiseau is going to.
I think Mr. Loiseau is going to speak to that.
Okay, thank you. Dr. Robinson, one of the things that is difficult within the Bryan Act is some wording about presentation of economics or determination of economic production. I know how I feel on it. What company is going to invest $1 billion and not know what all their costs are? Can you maybe walk through that a little bit of maybe a better methodology of how we should approach this?
I can speak to what we have in front of us. I can't speak for some of the other companies. We have to have certainty in place for what the royalty number is, as well as all of our other costs, as we get to the final point that we make a final investment decision. And like I said, there are many steps to that. So we have to negotiate offtake contracts, which can live for several years. The form of those offtake contracts in the lithium world is complicated and diverse, and depends very much on who the offtake partner is. We have to put in place some equity, so we have to raise some capital. And then we have to, like I was saying, negotiate the project debt, which is the largest portion. Debt is required to finance the project. And so in order for us to move through that, to get a final understanding of the capital costs, we have to not only complete the engineering, but also engage with the contractors who are going to construct the project. We have to engage with the vendors who are going to provide us the specialist equipment, again, some of which has not been installed at any project on the planet to date. And at the end of all of that, we have to understand the totality of those inputs into our financial models, and we have to make a decision as to whether we can afford to build this project or not. And that's done with our partners, obviously. For us to move through that development process, we need the fiscal regime to be set early. It's just that simple. And so there is a chicken and egg situation there, which is frankly unavoidable. Without this royalty being set, the projects they won't happen. Unfortunately, it's that simple. And we can point to regimes regionally where the royalty is set. So in Texas, we have an established royalty. We know what it is, and it's favorable. And so when we think about where we deploy our capital, that will absolutely play into our financial decisions.
Former hearing officer Bill Wynn used to have a statement, I think he applied to me, that I was blissfully unencumbered with a law degree. So I'm going to roam off into that a little bit. When we look at the language within the Bryan Act, and perhaps the attorneys can address this, because I know that Mr. Perkins is probably going to take a different view. is there a way that we can accept testimony that says your stress test economics at a royalty number will be economic? And then at a later date, the determination of profitable production happens as a trigger for the payment of the royalties. So at some later date, there's a hearing that establishes that you have now constructed the plants are functioning and are profitable, and that becomes the trigger point. It's almost like our first production reports for gas wells in North Arkansas or whatever. But, some type of regime like that we then know that royalties are going to commence on that project. And so that two-step becomes a way of solving this sticky language within the act. Does that seem reasonable?
I think if we had no alternative option, that might be great. Again, I'm spitballing here, right? So. But I would just, as a business decision, where there is uncertainty, that makes investment less likely, and it's that straightforward.
But what I think Commissioner Walford is saying, we could determine the amount that will be due, but it won't be due until the trigger is pulled, and I think that is actually correct. It won't be due until the trigger is pulled. And my interpretation of the act is that the royalty owners would demand that the trigger be pulled because we're now entitled to a royalty. And I would expect with these co-applicants, the royalty owner wouldn't have to demand, we would agree. This whole business about profitability is boggling the positions that I see taken, that this is going to be wildly profitable and we've got to have all this money, but they've got to prove it's going to be profitable. That doesn't make much sense to me. But yes, I agree with your analysis, Commissioner Walford. I agree that you can determine what it will be, and then it isn't due until profitable extraction occurs, which is probably going to be in a couple of years.
And I'm just merely looking for a methodology as an oversight institution to know when those things are triggered, and thus protect the relative rights of the royalty owners, where they're not having to actively pursue their royalties, but we know the trigger date, as we know a first production date on wells or whatever.
Yeah, and I think ultimately when you have regulations, whatever form they ultimately end up in, that's probably going to be in there.
I'm looking at Mr. Perkins now. No, okay.
Any other commissioners?
Dr. Peterson, kind of develop what they were speaking about a little bit. As I'm sure you're aware, the Bryan Act requires that, this be found to be profitably extracted. I won't get into the argument on when or how that will apply, but let me ask you a question. The statute specifically goes on and further delineates how that's done. And it basically says that it shall be determined by the commission on the basis of the value at the time of extraction without interest after deducting all cost of producing and recovering the same. My question is this, and I know that at a prior hearing, I think y'all introduced your definitive study and went through some things, but is there not a way that Standard Lithium can present that even? I know it's a bit of a chicken and an egg problem, but making some very liberal assumptions and still make that presentation to say, yes, after deducting cost of producing and recovering, it would still be profitable? Or do you think that is something that at this point is not?
I mean, if I speak to and I'm going to use the Southwest Arkansas project, so the one in Lafayette County as the example, we still have a lot of work to do. So yes, we produced a preliminary feasibility study for that project. But as I said, we've entered a joint venture on that. We've redesigned the project. We're now making a different product than was presented in the PFS. And so any estimate of project economics right now is, I'm just making it up, frankly. So it's difficult to do that. We need the studies to be complete. We need to engage with the groups who are going to lend us the money. We need to negotiate the offtake contracts with the people who are going to buy the product. And I think this is one other thing, is that quite often an offtake contract might be at a price which is less than the market index price that we're suggesting to users, the study. And so we need all of those things to be in place before we can genuinely understand the project economics. So there's work to do. I think, as we've said, I think a couple of times from different members of the group, the reason that we're here is we think it can be done. We think it can be profitably extracted from the brine in the Smackover Formation in southern Arkansas. That's why we're here. That's why we continue to spend millions and millions of dollars every year to move these projects forward. And so that is our belief. And until the studies are done and the work is complete, economic assessments are, that not really worth the paper they're written on. You need to have done the work.
Thank you.
Let me also address that, because from the legal end, that's precisely Judge Moulton's analysis in his memo, which the commission adopted yesterday, is that the burden is to prove that it can be commercially extracted. And I'll add one other thing, and that is in the docket that we spoke of yesterday in 2007, where the salt royalties were approved. One of the discussions in adjudication, and you could read this in the brief, was, well, we're a little hung up on this profitability, and the answer was, if they didn't think it was going to be profitable, they wouldn't be investing $100 million. And that's the situation.
Absolutely. And I don't disagree with that. And I've actually read that transcript. The issue I have with it, I wasn't a part of that hearing, but I think that still doesn't get you around the language. So certainly this commission could go whatever direction they want. But I think if you don't comply with the standard, you're creating an issue that likely is going to resurface.
As of yesterday, the standard is can be extracted.
All right, any other commissioners? Based on the line of questions from the commission, any follow-up from council? Mr. Daly?
I have nothing to ask about this witness. I would recall Mr. Owasso for just a couple of questions.
Hold on a second. Mr. Perkins?
Yes, Judge, thank you. They referred to this graphic from the USGS study, and Commission Chair Langley asked about the language there. I just want to point out that is merely a screenshot of the actual USGS article. That's not language that we added to it. I don't pretend to explain exactly what that statement means, Commissioner Chairman Langley, but I wanted to make clear that's not commentary from our side. That's merely a screenshot from the article. And I would just point out that, of course, this map only shows lithium concentration. There are other really important elements to the fact that Arkansas is the sweet spot, and those include the thickness of the Smackover Formation and its permeability, its time-proven ability to produce economically and efficiently the brine from that formation, as well as the fact that we have a very well-settled law about who owns the brine. None of those things are equal in Texas.
All right, thank you, Mr. Perkins. Ms. Daly, your next witness.
Recall Remy Lovato?
I am so sorry, Mr. Hickey. Doctor, could you come up, back up? My apologies. Yes, sir.
Good morning.
Morning.
Thank you for taking the time to speak with us today.
My pleasure.
So I think that you all have taken the position that the regulatory and statutory framework here in Arkansas is conducive to develop this industry. Is that correct?
We looked at Arkansas as an area with potentially good resource. We thought that the existing brine production framework was helpful.
Great. How about the infrastructure that's already been laid down into the ground? Was that a factor to bring y'all's operations and capital investment to this community?
For one of the projects that we're involved in, yes.
Yes.
For one of the projects, no.
Right. So when you look at the statutory framework, I think it clearly states that once you start pulling something else out of the ground, other than the bromine, something else out of the brine, then you have to go to the commission and account for all of your cost and net that against the value. Would you agree that that is a correct review of that statute?
I'm not a lawyer, so we ask counsel for opinion on that sort of thing.
Okay, okay.
Because I'm the attorney. Like it or not.
Mhm. If you'd like to say something, Mr. Daly, proceed.
The answer is yes. If a producer extracts a substance profitably that was not profitably extracted on or before January 1, 1979, then that producer must make a fair and equitable accounting to the landowners, royalty owners, for doing so. That's what the statute says.
Yes, sir, I agree. So I guess my question to you is, because of the statutory and regulatory framework, and it sounds to me that y'all were aware of that when you came here to try to pull the lithium out of the brine, I would think that when you entered into these agreements, you went into it eyes wide open, correct? Knowing that eventually you were going to have to come to the commission and show your numbers. And even if you sign something that is subject to a confidentiality provision, that was done after you knew that you would actually have to come to these gentlemen up here and show what y'all have done. Is that not correct?
I'm not sure what you're. I'm honestly not sure.
Yes, sir. I guess what I'm saying is that I know your attorneys, and I think they're very good attorneys, and I think they probably advised you all at one point or another that you're going to have to go to the commission and show your numbers. And it appears to me that your group has not been willing to do so. And I mean, I'm wondering why you came here and availed yourself to this regulatory system when you knew that you were eventually going to have to open up your books and show these gentlemen that these are your costs and that you can profitably extract it so that they can determine whether or not something is fair and equitable. I couldn't hear you, Mr. Daly.
And the objection is that it assumes multiple facts not in evidence.
I'm not even certain what the question is, to be honest
Okay.
with you, Mr. Hickey. Are you asking the witness about his conversations with his counsel?
No, sir, absolutely not. So
Okay.
I guess what I'm asking is that when you look at the statute, I think it's pretty clear what they have to do. And they've continually said that they would not show the cost. And so I'm asking, why did you come here if you knew that you were going to have to open up the books and show the cost?
It was as he assumes a fact of what the witness knew, which is not in evidence.
Yeah, I'm going to go ahead and sustain the objection.
Okay.
Can you, do you have another question, Mr. Higbee?
No, sir. No
All right.
further questions.
Thank you. All right. Thank you, Doctor Perkins. All right, Mr. Daly, next witness, please.
Our, Remy, you've been previously sworn. Were you, you've examined the objection filed by Mr. Perkins on behalf of South Arkansas Minerals?
Yes, I have.
And does it include a brine lease executed by, or actually several, 5 brine leases or 4, I'm not sure how many, executed by certain parties, and one of them's not even executed, in favor of a company called Folsom?
Yes, I've seen those leases.
Have you looked at those leases to make your interpretation of the royalty clause?
I have.
We need to look at the next slide, if we may, please. There we go. Is that royalty clause reproduced now on the monitors?
Yes, it is. I believe there's a typo in the one word entitled is actually missing in the copy, but it is otherwise complete.
Okay, I can't hear you very well.
I have noticed that there's a typo. It should also include the lesser shall be entitled to a 10% royalty. So just highlighting that, but the true lease itself is also an exhibit.
Well, what do you see in that lease as to the basis for the royalty?
I think this was a topic of discussion earlier when this lease was first presented on a line of discussion, but it focuses on 2 aspects, not that dissimilar from the type of construct that we've presented in our own proposal. One, a quantity basis, and one, a price basis. And so in reading this lease and looking specifically at those that are highlighted at the start and the reference to lithium compounds, calcium chloride, or other, and goes on to list that are extracted from brine. And I think that's an important consideration, again, to highlight that in no aspect or anywhere within this lease does it reference that the quantity to be paid upon for this lease has to do with specialty products like lithium carbonate or lithium hydroxide that are not extracted from the brine. And so I know we spent a lot of time discussing the equivalency example that we highlighted at the beginning of this hearing. And it's my opinion that this lease actually does exactly as that equivalency was highlighted. It recognizes that the constituents within brine are simply those like lithium and others. And though it may afford a point of sale that is farther upon for the extraction of those minerals, and they may ultimately be made into a marketable product, the quantity that is in discussion here is simply that which exists and it occurs from minerals extracted from the brine. To say another way, if you recall, as we presented the equivalency of a similar concept for our own lease proposal, our own proposals here at a 1.82 of lithium carbonate equivalent, what's equivalent to a 9.68. I would view a 10% lease in this aspect being equivalent to a 1.88.
This isn't your lease.
That's correct. It's not. I merely wish to highlight that it being presented in evidence as a view of the highest and best on offer leases in Arkansas. It is my interpretation that this would be one that would pay the equivalency of a 1.88 lease on an end product.
And you don't have any leases that have this particular royalty clause?
We do not.
Would you just discuss the array of leases in Arkansas that Saltworks does have?
So while, as I've said before, I'm not going to comment on the specifics of any proprietary or commercial or competitively sensitive information, I can say that we hold a variety of different lease and lease constructs within Arkansas and across the areas that we've represented. In all of those, they either reference the aspect for the commission to establish those leases. They contain constructs that are lower than the presented here, or they contain constructs exactly equivalent to that of the proposal here for all leases that ExxonMobil and SolWorks hold within Arkansas.
Let me then change the subject. We heard discussion yesterday about how it would be advantageous to be able to set special different royalties for different units. Do you agree with that?
I do not.
Explain why not.
For a variety of reasons. Again, what we're looking to do here is look to the contributions of a resource or a mineral into the overarching variety of different types of projects and refining that would ultimately take to develop lithium resources, whether those be projects that develop lithium carbonate, lithium hydroxide, a variety of different alternatives. So in focusing on the mineral itself as that basis and understanding how fair and equitably can be applied to all mineral owners across Arkansas through a variety of developers, through wider areas, it is my view that a consistent methodology is the best example for fair and equitable accounting to mineral owners.
Let me change the subject again to a lease that was presented and represented to be one of your leases in Texas, the Gulf somebody or other lease.
I'm familiar with the lease.
Is that in fact one of your leases?
So I think it's first important to highlight that the lease and the objectors exhibit appears to be unsigned. So it's impossible to tell whether it actually reflects an actually executed lease. But I can tell you that based on the lessor and the property acreage, I can confidently state that ExxonMobil does not have or own the rights to any such lease.
Finally, Ms. Anderson testified yesterday and expressed the view that once the wells are drilled, you'd all be back in Houston and the good times would have ended for South Arkansas, so to speak. Can you speak to that?
Yes, I can. If you recall, commissioners, at the very beginning of our presentation, we talked about the potential economic multipliers that may exist from a large industry development. And an example from World Bank was presented on that. But to say that the only compensation or the only area of value or economic growth that exists in the development and long-term basis of an industry comes from royalty payments, I would say is incomplete. Again, when you look to the broad aspects, while drilling of wells may be completed and once production begins, what remains in the complexities that we highlighted are large plants and facilities that will continue to operate in refining businesses and specialty chemical businesses for potentially decades to come. Those will include jobs, those will include taxes, those will include other economic development and growth opportunities that companies will continue to invest with. So to say that royalties are the only method of compensation and continued value to contribute to economic development following the completion of a project, I think is inaccurate.
I pass the witness.
Thank you, Mr. Daly. Mr. Hickey?
No questions.
Stovall? Mr. Perkins?
Yes, Judge. Thank you. Mr. Loiseau, you mentioned the Gulf Atlantic Resources lease, and you were very careful in the way you answered the question. You said you can say that Exxon does not own those interests and that it wasn't signed. But you will admit, will you not, that Gulf Atlantic Resources is in fact a lease broker for ExxonMobil?
They are not currently a lease broker for ExxonMobil.
Okay. That's all I have.
Thank you, Mr. Perkins. Mr. Pilkington? Mr. Daly, any follow-up? Any follow-up for your witness? All right, commissioners, any questions?
I know you and I discussed this a little yesterday, and I guess at the danger of beating a dead horse, I want to clarify a little bit. You just went through this lease provision, and I want to make sure I have a good grasp here. Basically stated that the 10% royalty in your interpretation would be equivalent to about, I believe, 1.8 something of the proposed royalty rate. Is that, I think I said that correct. Would you agree with that?
Yes.
Okay, here's my question. Doesn't that make an assumption that the 18.8% of lithium in lithium carbonate is valued at the same amount as the balance of what's in lithium carbonate? I think I'm asking that correctly. So in other words, try it a different way. Doesn't that make an assumption that the makeup of lithium carbonate, the pro rata amounts, all have an equal value?
So to establish equivalency for an approximation, that is correct. In respect to this specific lease, I'm simply referring to the quantity of which a price should then be multiplied that I would reference and take from this lease, the quantity or mass of product that is developed and sold. That the quantity of that can only be construed as the quantity of the mineral that originates from the brine, and thereby would be directly proportionate. In other words, the quantity would be 18.8%.
Okay. And I would just want to ask you, I'm curious your opinion. How would one go about, in your opinion, determining the value of the various elements or substances that go into lithium carbonate? Is there a way to do that? Maybe it's a better question.
I do not believe that there is a simple and complete methodology to do so.
Okay, thank you.
Does your company file the leases of record in the county in which they're taken, or do they file a memorandum of lease?
Our typical practice for brokers or others is to file a memorandum of lease.
Any other commissioners? Commissioner Phillips?
So, Remy, that's the biggest question and void I have in my mind is the point that he just made is, the value of the oxygen, the value of the carbon, the value of the lithium, the value of the lithium. And I'm having trouble understanding that. I understand how you presented it. I get that. But I'm having trouble with the 1.8% of the overall product and acting like it's 10% of what they're getting, when in all actuality, if 10% of that 18% of the lithium would be on a complete different scale.
I would agree with your statement that is complicated to do. As you say, that is a mass-based basis and not a direct value. So in representing that, I'm not attempting to represent that anything beyond that is a mass equivalency type basis for that. I would like to instead bring it back to really, and our proposal is not based upon it being a 10%. That is merely an example to help people contextualize concepts of numbers and differentiation that may be presented in a variety of different formats, as in this lease as an example, where you need to understand things like quantity and others. It's complicated. There are differences all over the place. If you go back to the basis of our proposal simplistically looks to statutes and the precedent set by this commission as the basis for the equivalency of valuing a mineral or substance based off the ultimate percentage or equivalent percentage of end value products, and then seeks to apply that in a similar methodology for lithium products. And I would draw attention here as well, again, as you state, the variety of complexities in understanding that valuation and the need to attempt to normalize and come up with that. It is my opinion that, looking to markets and looking to well-established markets and producing jurisdictions and other areas and understanding across the variety of different royalty constructs and schemes, and even those pay on different portions of the value chain. Some pay on minerals, some pay on end products, some pay on other areas. That to be able to have a more normalized view of benchmarking that is supported by markets, that is supported by development, that is supported by investability, provides a clear basis and understanding of how markets are valuing on a royalty basis, an equivalency of end products for compensation to mineral owners. And so in that example, again, you can look to the Ernst & Young study that was provided. the average benchmarking across all existing producing jurisdictions, and the simple average that was presented of 2.1.
Well, you did a very good job yesterday of presenting it to make it believable and simplistic and understandable. But I still have an issue with comparing the atomic weights back to the atomic mass and calculating how oxygen, which is basically a free element, carbon.
And as I've said, that is just a mass equivalency basis to support understandings of in leases that say for this example, where the quantity needs to be evaluated because it is to only be paid on the mass or the quantity of that. You need to be able to understand examples and
I understand what
contextualization.
you're saying. So where I see it, my issue is, we got one shot at this, okay? And we got to get it right. And if I guarantee you, most of these people in this room sitting out there yesterday thought in their minds at your presentation that they were going to get 10%, and they're not getting 10% of the carbon. I believe they think that. I'm not saying what you said was wrong or indecisive or deceiving. I'm not saying that. You said it correctly. You did a good job of that. I'll give you that. But I also think that there's another side to this that, people aren't going to be getting what they think they're going to get. And I think several of us understand that. But we got one shot at it. And that's why I'm trying to get it right, because we have to get it right. Because
If I may add some comment to that, I mean, there was nothing that I would like to see more than Arkansas's resource development. We've seen, through the USGS examples and other areas, the assessments of in-place resource for the region and the opportunity that it has for the ultimate recovery of that resource. Now, we all know in-place is very different than recoverable resource. But there's a big differentiation between Arkansas's resource and what it needs to take to ultimately develop and other resources that exist today. Arkansas's resource is a deep brine resource. Arkansas's resource will require direct lithium extraction technologies or other similar technologies. Arkansas's resource will ultimately require extensive refining to develop marketable products to enter into a global supply chain. That is the reality. This is a globally traded commodity of specialty products. And Arkansas's resource will need to be competitive within that global supply chain and recognize the complexities that will exist in enabling the development of that resource, all of the costs, all of the technology, all of the capabilities, all of the operations, all the raw material costs, all the other things to ultimately develop specialty chemical products. And when you understand those supply and demand dynamics, when you understand the variety of other producing or emerging jurisdictions that exist within there, it is my belief that is why understanding global benchmarking is imperative to positioning Arkansas for the ability for its resource to be developed ultimately.
And I'm glad you said what you said to my point yesterday about you drilling 8 wells and plugging them and spending all that money that in my opinion, what you just said backs up what I say. I mean, you're throwing the cost factors in there, but yet we just went and did all that and wasn't worried about it because, millions and millions, what, $10 million, $15 million? I mean, that was where I had an issue with that. Don't use the numbers on one side of the equation, but on the other side, not worry about them, because that is a real cost. I mean, you've already spent a fortune down here.
That's correct.
I understand that.
We have made significant investments to date to evaluate the resource opportunity here and to understand what its potential for development could be. That is nowhere near the hundreds of millions to billions of dollars of continued investment that would be required to progress. And without something like physical certainty, without something like a competitive royalty structure that considers and could position Arkansas for entry into the global supply chain, those types of investments would be unlikely.
So with what you just said then, all the money that you spent to gather the information, to do the study, to see what the possibilities were. What are they?
I'm not going to discuss directly confidential information.
That's where the two trains meet on the track right there. That's my point is, you know.
Forgive me, Commissioner, but to say that understanding the cost of appraisal wells to evaluate a resource has something to do with the royalties to be paid on it, I struggle to draw the connection.
That's no further questions.
Any other commissioners, Commissioner Stacks?
Sorry, just a little follow-up on that. For purposes of value, going back to that question, and I'll term it in let me put it in terms of a project, a specific project, and a snapshot in time as to price. Could you not take cost in taking the lithium extraction and turning it into lithium carbonate, deduct those costs and expenses from what's received and determine an actual percentage of value that lithium plays?
I think that would be an incomplete methodology. I think it would not value appropriately the additional, non-direct types of costs and value that a developer brings, whether that it's capabilities, it's intellectual property, it's technology, and other areas. The value offered by a developer to take a resource and manage it throughout the life, to bear the risks of that capital investment, to bear the risks of the markets, to develop customers and markets, to ultimately bring technology and operational capability development. Those are all things that are well beyond just direct costs and numbers.
Sure. And I understand that. And that's why I said a specific project, right? Because depending on the project, the cost may be different depending on the technologies, and a snapshot of a price. But would you agree generally that you could come up with a value, at least for that project, of what that lithium would be worth to that operator or developer?
Again, I think that would be a challenging basis to do based off the variety of uncertainties and ranges, because all of those would still be hypothetical at that point in time.
So, not a question. I just want to make this statement. I want you to understand. Not a single person up here, not a single person in this room, even the people on the objection side of the table or anybody who was here yesterday, nobody is opposed to this project moving forward. Everybody supports it. I want you to think that all these people that are here, they're in support of getting it done. They just want it right. They have their interest. Y'all have y'all's interest. And I just want you to respectively understand that nobody's trying to beat anybody up. We're just trying to get it right and get it fair. And it's one of the biggest things that I finished this term. I'll have been on here 18 years. This is by far one of the biggest dockets that we've had, that we've dealt with since I've been on here. So, but that's it.
I would offer nothing more than an appreciation for the level of diligence and time and review that the commission has afforded this through that process. Ultimately, it'll be the commission's determination and decision on a fair and equitable basis. I believe that our proposal is as such, but I really appreciate the commission's time and thought and diligence and focus and shared desire.
Thank you.
Any other commissioners?
I'll finish up last question, and then we'll move forward. Going through this process, was a consideration ever made to offer, rather than the proposed royalty equation, I'll call it that, was there ever a conversation or have y'all considered, or maybe even what issue do you see with just a flat royalty rate with deductions of your costs? Now, I know a lot of people don't like that because there becomes potentially an argument of what those are, but can you kind of shed some light on any concerns you would have with that?
I think there are a variety of different constructs that one consider, but when you look to actually what's come most to bear on our side is when we speak with mineral owners, And what they're interested in, they are interested in a gross style royalty, one that does not allow for deduction of costs. And that is because, cost risk and developer cost risk in other areas, and we talk about the risk that developers bear, whether that be market risk in other words, mineral owners have overwhelmingly, to me, specified that their preference is to not be exposed to those types of risks and deductions in the royalty construct.
Would you agree if it was paid in that way, though, that would allow to make sure that the developer was essentially retaining its cost and further developing that product to a marketable product?
Depending on values in other areas to determine whether or not that would be truly a total consideration of what a developer is bringing, that would be a hypothetical assumption at that point.
Okay, thank you.
Any other commissioners? Director, did you have a question?
Now, maybe it's a question, maybe it's a statement, I'm not sure when, but following up on the volumetric aspect of what you were testifying to bring this down to some nuts and bolts, 2,000 pounds of lithium carbonate. Obviously, if you multiply that by 18.8 on a volumetric standpoint, 376 pounds of lithium are in that ton of lithium carbonate.
I'm going to trust your math, but that sounds correct.
Maybe there's a decimal point in there, I'm not sure, but. So the mineral estate is contributing 376 tons of product to that ton of lithium carbonate.
That's correct.
300 pounds.
300 pounds. We already messed up. So where does the carbonate come from? Obviously, the lithium comes from the brine. Where does the carbonate come from in that product?
So the carbonate comes from a combination with a variety of other chemicals and materials, soda ash being some of those. There are caustics involved in the process and a variety of other aspects. It also goes through, obviously, a refining process to create that crystallization effect that creates the product itself.
But those have to be purchased by the operator and combined with the lithium.
That is correct. Both the raw materials need to be purchased and all of the capital equipment needs to be invested in within to create that product.
So when you look at this lease provision, which I know is not your particular lease, but 10% royalty, that would only be 10% on what you get out of the brine, which would be the lithium.
That is my interpretation.
10% of the 376 pounds of lithium would be the mineral owner's royalty.
That is my interpretation.
Would you have any idea what the value of raw lithium would be, the metal? I mean, it floats on water, it's very unstable in nature. It actually doesn't even occur in nature. What value would that 376 pounds of lithium even have if you didn't make something with it?
As an unrefined or unprocessed or unpure or basis, the ability to determine that value, I believe, would be very, very challenging. And that is the challenge we presented at the very start of this presentation, which says, that is ultimately what we are attempting to value. We will need to look to some form of equivalency and consideration for that basis in order to do so and to allow markets to express and dictate that value. You need to ultimately look to specialty end products, but those are not the same thing.
And when you look for that, and I'm sure there must be a mineral standard or a metal standard somewhere. The only thing you can find is the value of lithium you take for your mood enhancement. So that's pretty expensive at the pharmacy, but that's not the lithium we're talking about. So using volumetrics to determine what an eventual royalty would be appears to make sense.
Again, and recognize even as leases as this, such as contemplate and to understand what a mineral owner is contributing to a resource, its vast or its volume or mass in the instance of a substance. I think recognizing that is a quantity that is being contributed is an appropriate focus.
If you were to use return on investment to determine a royalty, you would have to have a different royalty for each unit. because some units do not have to drill wells. Some units already have the brine available. Some units would have to purchase the brine. Each one would have a different ROI. And if you based a royalty on that, they'd all would be different.
That's correct. And considering as well the extreme basis that ROI will never be guaranteed, that it has been conflated that a return on investment or an IRR, a rate of return for the development or profitability of a business is ensured. And that is definitely not the case in any scenario, and nor should it be restricted. That will go through a variety of uncertainties and ranges throughout the life of a project that the ultimate ROI or return on investment of ultimate investment will never be known until the last day of that project.
When the commission looks at determining units for oil and gas production, we look at the amount of money spent, the amount of barrels produced to offset those costs. But the royalty set on the oil is 12.5%. No matter what the expense is, no matter what the operator sells the oil for, it's been set 12.5% through history. It's just traditional. No one even knows where the 12.5% even came from. But there's no adjustment of that royalty on the oil produced based on the cost to that operator of getting that oil out of the ground in that unit.
That's correct.
So regardless of his return on his investment in that unit, he pays the same on the oil produced.
That's correct.
I would just remind the commissioners that the Oil and Gas Act and the Brine Act, which it's modeled after, and our role is to manage a resource. We're not an economic entity. The conservation of the resource is mandated. Matter of fact, every state basically has the same statute. I've worked in 2 different states. The model statute the Interstate Oil and Gas Compact Commission passed mandates that the role of the oil and gas commissions are to conserve the resource and prevent waste. Conserve resource in the oil and gas realm means that we maximize the production. We protect the correlative rights by minimizing waste by establishing well spacing, the number of wells per unit, the number of wells per zone, allowables, setbacks from property lines. Those are how we protect the resource, at the same time protect the correlative rights by not allowing overproduction, maximizing the total recovery of the resource so that the mineral owner gets the maximum amount. If you look at managing the resource to determine what a royalty would be, in oil and gas, it's easy. We have 12.5%. It's been set for 100 years. Regardless of how much money the operator makes or loses, the mineral owner receives his 12.5%. It's standard. It's not based on any economics at all. Unfortunately, brine at the wellhead has no value. There's no 100-year history on what that should be. So all we have is volumetrics as a resource, because to take a royalty of a produced product, in the case of lithium carbonate, would be similar to taking a royalty of the produced products from a barrel of oil. You pay 12.5% on $70, $80, whatever it is, but that barrel of oil may produce $300, $400, $500 worth of products. The royalty is based on the raw wellhead value, not the product value. Unfortunately, brine does not have a wellhead value. All brine has is the next saleable product, which happens to be lithium chloride, maybe lithium hydroxide. But if you're going to use a similarity with oil and gas, the wellhead product is the lithium, By using volumetrics, which would be fair, the mineral estate is contributing 18.8% of the product that's being sold. And so the value of that 18% was what the royalty would be. This particular lease says 10%. And I'm not going to practice law, although I do think I have a BAL, bureaucrat at law. But there's enough lawyers in this room to have a constitutional convention, so I won't offer an opinion on what this says, but that's what it says to me. So the royalty owner in this particular case would get their share, which would be 376 pounds of lithium from that product sold. That would be the wellhead problem or value. What the value of that wellhead lithium is based on what you sell the product. So 376 pounds, if the royalty owner were to get 12.5%, let's say, make equal oil and gas, off the top of my head, they get 47 pounds of lithium. If you give that a value, it's 2.35% of the ton of lithium. You can use the 10% and you get 1.87% of the total value. The 1.82 that's been proposed is 9.68 of the value. To value each individual element would probably be impossible to do because the market value of that is different throughout the country. Whoever's buying oxygen, whoever's buying carbon, you couldn't do it. You have to do it on volumetrics. To me, if that makes the most sense. So the question will be, after I make my statement, would you agree with that?
Yes, I would.
Any other commissioners?
Remy, I want to talk to you about this. I've been listening to everybody. Are y'all going to produce like 15 tons of raw a day?
So we have not made final determinations for a specific project scale or volume.
Okay. I believe Standard Lithium told us a few months ago or a year ago that a well would produce 15,000 barrels a day. And so if you break that down, 1 ton of raw is 376 pounds. It takes 5.3 tons to make a raw ton of pure, let's say 376, and you divide that back, it comes to 5.3. What would be the price on that ton? Would it be 10,000?
Without seeing the math in front of me, Commissioner Langley, I'm sorry, but I'm struggling to follow.
What's the price today? 10,000, 12,000?
The price today of lithium carbonate?
Yes.
The price today of technical lithium grade carbonate is approximately, I think, $12 per kilogram, or $12,000 per metric ton.
Well, where I'm trying to go is the same number he come up with. I come up with, it takes 15.9 tons to make 3 tons of pure. So you got it kilometers. Can you convert it to tons and tell me the price?
I would need to understand exactly a little more specifically your question. But if I understand, I think your line of questioning, which is it possible to, from a similar LCE type conversion or lithium conversion, in other words, understanding the lithium content in something and understanding then based what an equivalent price would be based upon that, would it be possible to do so? Is that in a sense
Yes,
The question, and the answer would be yes. It would follow the exact same, whether the example that we brought forward through, or you could follow the exact same process to do so, and you would end up with a different equivalency price or a different equivalency basis. But it would end up in the same because you're using the same factors to understand the ultimate lithium's contribution from a mass basis into that product.
thank you, sir.
Any other commissioners? All right, based on the line of questions from the commission, any follow-up from council, Mr. Daly?
Not for me, Judge Malden.
Mr. Hickey?
No, sir.
Well, Mr. Perkins? All right, then.
Thank you.
Mr. Daly, does that conclude your rebuttal presentation?
Yes, it does.
All right. Council, you ready for closing statements? Or do you need to take a 5-minute break to go ahead and get yourself situated for closing? What's council's preference? 10-minute break. I've been informed by the commission that we are going to go off the record for 10 minutes. Commissioners, you ready to proceed? We are back on the record. If folks could take their seats. Mr. Daly, I assume you were going to be doing the closing for the co-applicants. Is that correct? All right. Mr. Parkins, Mr. Hickey, are you going to have closings as well, I assume? Just you? Mr. Hickey, you having a closing too? All right. Mr. Soba?
I would adopt and join this one. Mr. Perkins.
All right. Ms. Pinkleton, are you having a close? All right. Mr. Daly, please proceed with your close.
Thank you. And thank you to the commission and Director Bingle and Judge Moulton. This isn't easy. It is stressful and tiring and clearly intellectually challenging. We all sincerely appreciate what you're doing. And thank you for those nice people who came to watch. I know they have interests. I hope they have learned a great deal. As has been pointed out, it's sometimes difficult to learn this stuff unless you spend a lot more time with it than just a couple of days. But hopefully this has been informative. The commission's being asked to establish a fair and equitable royalty design to be applied when lithium is profitably extracted from the brine. And all of the co-applicants have expressed their belief that they can extract lithium profitably, though some of that is dependent upon the decision that you will make in a few minutes. And that determination, as we've expressed, needs to be made now so that the companies can make the business decisions to invest the literally billions of dollars necessary to build out these projects. It's our position that the substance to be valued is brine, and that brine will be worth something more than it's worth today if lithium is being extracted from it. It's also our position that there's a statutory royalty, now $65 and a nickel per acre per year, which has to be paid when the brine comes out of the ground, even if you don't take anything out of it. That's what statute says. And this is an additional royalty which will be attributed to the additional value that raw lithium chloride brings to the brine, because down the road someday, it can be converted chemically, combined with other substances and converted chemically into saleable products, the most common of which is lithium carbonate. But as you've heard, there are other products as well, which can be balanced back to lithium carbonate by comparing the lithium molecules therein. That's LCE. Judge Moulton determined after our pre-hearing conference that the requirement as to profitability was to prove that you can. And we believe we have proven that we can. The policies enumerated in the Brine Conservation Code, as quoted very recently by Director Bingle, to foster, encourage, and promote the development and production of brine. In order to accomplish that, there must be a competitive royalty structure. If lithium carbonate, lithium hydroxide, lithium oxide, whatever, from Arkansas has to cost more than lithium, the same lithium product from Australia or Texas or wherever, then it's not going to be competitive because this is a globally competitive business. And that's the reason why you were presented with the Ernst & Young study with all of the global benchmarks. And then the statute says that its intent is to authorize and provide for the operation and development of brine product properties in such a manner that the greatest ultimate recovery of brine and the chemical substances therein is had. For no more than the brine royalty of $65 and a nickel a year, the producers can take bromine, but that's the only thing they can take. After that, they can take something else like lithium, physically and chemically, if they can make an appropriate return on capital, not just a profit, but an appropriate return on the capital investment to do so. We think that the co-applicants have submitted a proposal that meets the standard of a fair and equitable royalty. And the reason why that number was chosen at 1.82% of the finished product of liquid carbonate equivalent is not accidental. It is because that is the precedent that the commission set in an earlier hearing. And because when that calculation was made, it compared, and this is difficult to do mathematically because you have to convert acres to barrels, but it was made based upon the relationship between the brine royalty then existing and the market value of bromine being the only substance. Remarkably, because it was tied to an appropriate producer price index, that relationship has held true right through 2023. You saw the chart, you saw the numbers. It hasn't gone far away. The formula that we propose would be the same for all the units, which would certainly eliminate a lot of controversy, I think, on the royalty side of, your units getting more than my units getting. But it would not require the same dollars to be paid because the dollars are paid on the product when the product is manufactured. And if you have higher concentration of lithium under your unit, obviously, everything else being equal, you're going to recover more lithium into your product. So the dollars will actually be tied to quality, to unit quality, not to individual tract allocation. But the dollars will be tied to quality because they will be tied to the finished product, and you get from more quality, better quality brine, you're going to get more finished product, other things being equal. But it can be consistently applied by the commission without, I can't imagine the logistical issues of auditing a bunch of net back cost-based royalty schemes and trying to make sure that they were all fair and trying to put dollar value on things that are totally subjective, like the value of the intellectual property, the ideas, the science. What's that worth? A lot, but if down to the penny, I couldn't do it. I wouldn't want you to have to do it. I just don't think that's the right way to go. There's an advantage to the mineral owners. If you listen to the witness from Fast Markets, one of the things she told you is that typically the Fast Market Index is higher than individual prices by a little bit, because the individual prices are sometimes subject to discounts. And so the average typically they've seen runs a little bit higher than actual prices. But what's better is it's transparent. Fast Markets is going to send a report every 3 months to the commissioners, or to the commission staff, that is, and to the individual producers, telling them what the average price for LCE was over that period. Totally transparent. You can put it on the stub of a royalty check. Try to do that with all these costs that would have to be deducted. Even with the difficulty of figuring out what in the world they would be. Therefore it's transparent. And then look at the global benchmarks. And you can get all excited about Chile if you want, but the government of Chile is not a friendly outfit, and they own that industry down there, and they tell you what they're going to get, and there isn't any market about it. If you look at those nations which have systems of government similar to ours, you see these global benchmarks right in the same area, and that's the competition. I respect Mr. Perkins. I've known Robert Reynolds for many years. I have an utmost amount of respect for Mr. Reynolds. And in fact, I really enjoyed it when he was trying to go through that lease with all those deductions and came to the same conclusion that I come to, that it almost deducts you down to nothing. But I just can't agree that what they are proposing is not going to create a situation where these companies will not be able to be competitive, and therefore they will not be able to gain investment, and therefore this project will grind to a halt. And one other little thing, this is a tiny little thing, but it bugged me last night. And that is that for some reason we were told that a couple of leases that the state of Texas executed that had a fairly high royalty on minerals or mining leases were an appropriate benchmark. If you will look at this is their slide, and I have pointed an arrow, I believe accurately, at the counties, the 3 counties involved in those leases. The westernmost county in the state of Texas is El Paso County. The 3 counties named, Reeves, Culberson, and Hudspeth, are immediately adjacent to El Paso County. And if you look at that map and you see that black square where the USGS has defined the gross area of the Smackover limestone, and you look where the arrow is pointing, what in the world has that got to do with anything? I did, just out of curiosity, look at Google Maps, one of my favorite pastimes, and I can tell you that the county seat of Culbertson County, which is the center of those three, is 848 miles by road from Magnolia, Arkansas. If you prefer, you can get there in 797 miles from San Diego. That's where it is. I mean, if somebody's trying to fool you, I hope you weren't fooled. I'm going to conclude now. And what I'm going to tell you is that, just like Mike Davis told you yesterday, you can't make everybody happy. So do the right thing. We ask that the application be approved.
Thank you, Mr. Daly. Mr. Hickey?
Thank you, Judge. Thank you, Chairman Bangle, and thank you, Commissioners, for your time and effort. This process couldn't happen without y'all, so thank you. I'd also like to thank the co-applicants for trying to develop these resources. And as I told y'all earlier, I represent several different individuals and entities in different capacities as well. And the underlying theme that I think I would try to imprint upon each of y'all is that no one's trying to stop the co-applicants or anyone else from developing these resources. No one's trying to take all of their profits. But what my clients, and it seems to be that many of the people that are concerned about this, are wanting to make sure that they're getting their fair share of the mineral that they own. These are private property rights that are owned by individuals and entities in our state. I'm also thankful for the infrastructure that we've got and the capital investment over decades in the brine industry here, along with the regulatory structure and the legislative laws in place. And one of the main reasons cited for coming to Arkansas is that regulatory and statutory structure. And I'm glad that it's brought them here, and I'm glad that they're here, and I'm also glad that we've got that framework. Because I believe that if you look at the Brine Conservation Act as a whole, it not only encourages the development of these resources, discourages waste, but it also is there to protect the correlative rights of these landowners. And if you look at the mechanisms in place for the Brine Conservation Act, it's those of transparency. Okay? And so then I turn my attention to this 315C that we've beat to death. And I believe that the commission has been asked to set a royalty rate and determine that the process for accounting is fair and equitable. And when you look at that statute, there's two factors. We've got the value of the constituent part, the lithium in this case, and then the cost of extracting the same. You net the cost against the value. You can start having arguments about what those costs are. You can start having arguments about what the value is. But at the end of the day, you net the two. And how is an individual or a body supposed to sit down and make such a determination without all the information. And I believe that it's the co-applicant's burden to prove that the proposed royalty rate is fair and equitable. And in this case today, I do not believe that they have met that burden. I think at the bare minimum, under this structure that we're talking about, any costs that aren't included, that aren't disclosed, can't be used as a reason that this isn't going to be profitable enough to attract capital to our region. And I have no further comments. Thank you.
Thank you, Mr. Hickey. Mr. Perkins.
Thank you, Judge. Seems like it's been a long time that we've been trying to get to this point. Mr. Daly started out his closing by saying, this isn't easy. I agree. Like him, not nearly as many as him, but I've been in front of this commission hundreds, maybe thousands now times. I don't know. Certainly don't keep count. I don't think I've ever been before you that you've been more engaged, more concerned. I appreciate it, and I want to thank you for your service. One really quick aside, it's amusing that Mr. Daly thinks West Texas is really far away, but Argentina is really relevant. So I'll just leave that there. I want to take you down a little short history road here, using the exhibit that Mr. Daly added later into the record. It's the review of the work of the Governor's Brine Study Committee from 1977. And I just want to demonstrate how history seems to repeat itself on pages 17 and 18. I apologize for reading this, but it's not too long, so bear with me. It says the study committee demanded on many occasions to know what the cost of actual extraction of the bromine was from the brine in the producer's plants, and the companies steadfastly refused to divulge this information. Much pressure came to bear on the companies to release the information, and on Tuesday, July 13, 1976, the Arkansas Gazette published an editorial calling on the companies to divulge their cost figures in the interest of fairness to the landowners. The tenseness of the interplay between the actors in this drama is best demonstrated by reading a portion of the editorial from the Gazette of that date. Here's that quote. Before a royalty recommendation can be made, however, the committee needs and has sought all the information it can get from the companies producing bromine. It decided finally last week to ask the companies directly how many cents they are spending to pump a half barrel of salt water and extract a 25-cent pound of bromine from it before the committee decides on proposed legislation. Without the information sought by the committee, neither this body, the governor, nor the legislature can have the figures they need in recommending or setting royalty payments. In the circumstances, all three bodies would be fully justified in picking out a generous figure as Arkansas's only way of protecting the individual landowners who do not have the force of a $100 million industry to promote their interests. The message for the bromine industry should be clear. Put up the figures or be willing to accept what the state legislature sets. And the legislature has strong obligations to see that those who own the natural resource by virtue of its existence under their land are not called upon to sacrifice for the benefit of those who would extract and deplete the resources for their own apparently highly profitable purposes. By the same token, every company here has steadfastly refused to provide to you the economic information on their particular units, with one exception. Standard Lithium, because of, as I understand it, the Canadian securities laws, has to issue certain reports and pronounce publicly what those are. Now, interestingly, Dr. Robinson testified under oath today that, well, those are reports of technical disclosure that we use to attract investments from shareholders, but, and I quote, it's not the real economics we would use. But nevertheless, it's all we have, because every single one of them otherwise has refused to give you one single page of economic information on any specific project here in Arkansas. At the beginning, in opening statements, I showed a slide and I said, what should the commission do? And I said, deny the Big Five application and describe clearly what the commission needs from applicants in the future to set a lithium royalty. And then I went through some points on that, and I'll come back to it. But I had another slide and said, if the commission feels compelled to set a royalty rate, the best examples were at 12.5%, which was established by expert economic testimony last December based on actual economics of the Lanxess, Arkansas lithium project. 20% based on the same analysis for the SWA project economics. 10% from the lease examples that you were provided. And I put in 6.8% to 40% from the Chilean example, really more as making a point that what goes on in other countries where landowners don't own their minerals is irrelevant here in the state of Arkansas. I've thought about this, though, a great deal. And, you know, this is the way we do things in America before agencies and in court is we take sometimes extreme positions and hope that the decision maker comes down somewhere in the middle. It's just part of our adversarial system. I'm going to depart from that for a minute and tell you what I really think. And, you know, I'm not here to tell you what your job is. That's your job. This is a judgment call. It's a very difficult judgment call. But I have probably, with the exception of Mr. Daly and Mr. Honey, reviewed more information than just about anybody else in this room about this topic. And here's the conclusion I've come to. First of all, let's talk about reality. What happens if you deny the application today? If you deny the application, then we go back to square one, and who knows how long it'll be before we're back in here again with another session without any financial information from the companies, and we'll have this discussion again. That's not the best thing for the development of the industry. And as Mr. Hickey said and Mr. Daly said, everyone in this room wants it to happen. We just want it to be fair. What if you adopt 1.82%? Well, here's what's going to happen is we'll appeal that. And there are critical problems with it, in my opinion, because they haven't provided any economic information for you to base that decision on from any specific unit in Arkansas. So is there somewhere in between something that you can draw from all of the information you've received that would protect the companies on the low end and allow the royalty owners of South Arkansas to benefit well as prices go up, if they ever do again? And here's what I would propose, that below $10,000 per metric ton, that the royalty rate be 3%. From $10,000 to $29,999 per metric ton, the royalty rate be set at 6.25%, which is half of what our economists testified to in December. Between $30,000 and $49,999, it would increase to 10%. And above $50,000, as high as it would ever go, 12.5%. That would, in my personal opinion, which you can take it or leave it, but nobody's really tried to propose a resolution here, and that's what I'm trying to do. I think it's fair to the companies on the low end. I think it allows the royalty owners to profit handsomely if lithium prices go up. And it would be an elegant and well thought out solution to this problem. There is one more really sticky legal problem that you're going to have to grapple with. It was pointed out during testimony. The hearing officer in this case decided, and you adopted, that this is done on a unit basis. Mr. Daly amended his application to list the units involved, though the only actual real units are the 3 Lanxess units, the Tetra Evergreen unit, and although he didn't mention it, there are 2 relatively small actual units inside Albemarle's production area. But you've, if I understand your rulings, you're going to simply include Albemarle as some sort of unit because that's historical. I'm not arguing about that. Where the real problem lies are in the hundreds of thousands of acres of sections that are listed on the application that are not in any unit or not in any proposed unit. And the applicants testified under oath that who they notified with regard to that are those parties they have taken leases from. So the parties that other companies other than the 5 applicants have taken leases from, or those parties who are unleased, did not receive notice of this proceeding. And I can guarantee you that that is a violation of due process. You can't possibly require a set a royalty rate today that will always be applicable to unspecified units to be created in the future where not everyone has been notified. What you could do, however, though, is adopt it for all of the existing units and create a presumption that that will be, you could even state that in the order, that this is going to be the presumptive rate for all future units. However, they will still have to come and file an application for that once units are created. And with that, again, thank you for your service and ask you to remember all of the correlative rights of all the parties in this proceeding. Thank you.
Thank you, Mr. Perkins. Mr. Pilkington, we did get some additional comments, written comments. I just want to make certain that they came in last night, they came in today as well. I just want to make certain that, and that is true, correct, sir?
I'm inquiring as the applicant, do I not get a last shot?
You do. I just wanted to make certain that I get this squared away. Sorry, Mr. Daly. We did get some additional comments.
That's correct. We believed we received 2 or 3 of them last night, and I believe we got a written comment earlier from somebody in the audience.
Right.
And those have been presented to the court reporter.
Just want to make certain that those have been incorporated into the record.
Yes.
All right. Thank you, sir. Mr. Daly.
Thank you. This will be very quick. Mr. Perkins' proposal for a sliding scale royalty won't work. It won't work because it will discourage investments and kill projects. But the main reason, the legal reason why it won't work is because throughout this process, they have ignored one of the most important provisions of the Bryan statute. And that is that when a party is integrated, that party is entitled to participate. And with, a bunch of options that probably wouldn't occur, the price that participant pays for wells, nothing else, and then sells its brine back to the unit operator for a price which is 8 times the royalty. When you get up to 12.5% royalty and you multiply it by 8, you know what that means? It means that he has set a royalty so high that a participant pays for the wells and gets lithium carbonate for free. the numbers just don't work within the confines of the statute. That's all I have else to say.
All right, thank you, Mr. Daly. Commissioners, based on the closing statements, do any of you have questions for counsel before I call the evidentiary part of the record to a close? Commissioner Wolford?
So, Tom, you're applying the additional substance clause as being applicable to the 8 times clause. Okay.
Well, that participant's paying for is going to be the source of additional substances.
And so that places a tension point, is obviously that you're stating of how high the royalty can go.
Yeah, I think you have to make the differentiation between the rights of a participant and the rights of a royalty owner. And if you set the rights of the royalty owner so high that you have created this enormous windfall for participants, you're gonna cause some real problems.
And just for clarity, this is set by statute, not
Yes,
by
sir.
rule.
Yes, sir, absolutely.
And it would create an inequity perhaps in that those that had enough money to simply buy into the brine unit could then get a free carry
Yes,
on a $1 billion plant
absolutely,
if it's set too high.
absolutely.
Look at it the other way, just to set expectations. If you were going to try to keep that 8 times at a level that may be economically acceptable, you would necessarily have to have the royalty somewhere below 5%, perhaps, maybe below 4%, so that the 8 times that number didn't become too cumbersome on the person constructing the plant. Is that a fair way?
That's the kind of math that I do as well.
So that sets, from your side at least, what the royalty expectation range can potentially be.
Well, yeah, added in with the global benchmarks and all of the other things. But yeah, I think that's got to be an absolute low point.
Mr. Perkins, in your proposal on the royalty, are those percentages based on the same calculation methodology that was presented earlier? Okay.
No, Commissioner Walford, and I should have clarified that. I apologize. So, using an outside service as a sort of a proxy for what's actually happening makes no sense. The one thing that is certain that will actually apply to each unit is the actual sales price of the final products. It's easy to determine. They can calculate royalty from that, and that's the way it should be done. And if in fact, of course, my suggestion was only a suggestion. If you think 12.5% is too high, then change it. But I was trying to, present an example of something that could potentially alleviate producers' concerns on the low end, but allow the royalty owners to share in the riches when lithium carbonate is at those really high prices.
Is it still is your opposition still, though, that the application be denied?
I think that it should be, to be honest. I mean, I don't think that they've presented the kind of unit-specific information, but I was trying to present a way to compromise if we could do so. And I think that the kind of approach that I laid out is something that at least the objecting parties that I'm familiar with and that I represent would be willing to accept, with the one exception of trying to include sections that are not in a unit, because I just think that's an insurmountable constitutional due process issue.
When you proposed this, were you mindful of the 8 times opportunity that a participant would have?
You know, I was not especially thinking about that. And there is language in the statute that it can be done on the terms that the commission determines. But I'm not, and I'm not going to disagree with Mr. Daly, because first of all, I'm not sure I'm even looking at the correct subsection at the moment in front of me. And like he said earlier, I'll send back to him. I respect his legal acumen about the Brine Act for sure. And you know, typically when a party participates, they're paying their share of the expenses. And so 8/8 would be an entirely appropriate amount for them to receive if they have in fact paid their proportionate share of the development costs. At least from the oil and gas context, that's the way it works.
The issue being here, though, that they can simply pay for the brine extraction piece and not have to pay for the plant and still get the 8X.
I understand.
Yeah.
And that doesn't seem to be right. So
I have struggled.
I'm going to admit the issue there. And so let's just change it, have 3 sections and make it 10% on all the way up. So when it gets really high, the companies are still making that 20% off the top when prices are very high, and the participating owners are getting a share of that.
One of the cautions, we spoke of former Commissioner Davis earlier, after living through Fayetteville Shale and several other things, are that world of unintended consequences.
Sure.
And I could see a scenario wherein a party might, I don't know the economics at this point of the decision to do so, but you could arbitrage yourself into an 8 times a 10% royalty and get an 80%, but essentially an 80% carry in a lithium extraction plant. And I don't know, is that number, it's unpredictable what that number would be. But at some point it grows to the point where it's not worth building the plant. Too many ticks on the dog. They're not paying for the actual construction of the plant at some point. So it seems that's where the tension lies in all this, that I don't know what the number is. There's no testimony to the number, but there's a lid that goes
Sure.
on it at some point. So anyway, thank you.
Any other commissioners? Stacks?
Mr. Daly, to your point about the 8/8, and again, as Mr. Perkins said, I'm sure you're much more familiar with the statute than me, but I'll ask you, let me start out with the provision in the Brine Act that talks about, I'm looking at it, so I'm gonna scroll down here. But that basically says what we've been talking about this whole time, that you shall account separately and on a fair and equitable basis for all substances which are found to be profitably extracted, which weren't formerly, okay? It seems to me that provision separates it from the balance of the act as to royalties and other things. And then so when you go up and you read earlier in that statute of 315, I'm curious, are you confident that you think that still applies to the lithium in this case, or is that more of an ambiguous thing to you?
My opinion, for sure. And I can absolutely promise you that if that were not the result, there would be a serious lawsuit about it.
So in your opinion, if this commission were to make a decision and in its order clarify how a participation would work, you think that was going to result in
I
serious litigation?
so advise clients.
Okay, thank you.
Any other commissioners?
How come this 8 times the royalty rate? Can you hear me now? How come this 8 times the royalty rate didn't ruin the brine industry? And yet lithium, it's out in a lithium sense.
Statutory royalty, which started out at $25, went to $32, is now $65, times 8 is what is paid to participants right now.
So it's being used, but because there was no price for a brine, or it was worth nothing, they're not.
I'm sorry, I didn't hear that, Robert.
But they're using the statutory rates, but because there was no price for brine at the wellhead, they couldn't.
There's a calculation that is required where you have to convert acres to barrels, and then you basically multiply by 8, and that's the way it's done. And I know you weren't on the commission when it was done, but it originated in the 3 Great Lakes chemical unitizations around 1990. And most recently, and I think you may have been on the commission when this happened, it was tied to the same inflation index. The participants' entitlement was tied to the same inflation index, but for a number of years, they forgot to escalate it. And so at one point in time, and by the way, Commissioner Weiser's company is one of the participants. He's recused, but that's an interesting study, I think. And you got a comment card from another one of the participants, a gentleman named Hans Burrow. They recognized that their joint interest billings were beginning to exceed their revenue, and they complained. And we looked into it and discovered that the problem was that the rate that they were entitled to had not been escalated for a number of years. And so we came back to the commission and did the math to increase the rate to the then equivalent. And now Lanxess returns to the commission once a year with a new number. It doesn't require a hearing because they just submit a letter, but that number keeps going up, tied to that particular wholesale price index that the whole thing's tied to.
Okay, thanks.
Any other commissioners?
I'm going to come back to this. I'm sorry. So as I read 1576 315 C1, okay, what we're looking at today is essentially determining that fair and equitable basis for substances extracted from the brine. And I know you said earlier, and I've got a note that it's the brine to be valued. Guess I would start there, and I'll let you. I'm going to state it that I disagree with you, but it's really my question because I want you to give me some insight. Because to me, the brine's been valued. We're valuing additional substances that haven't formerly been valued that are being extracted from that brine. So then if you go back up to 1576 315 B1, where the 8/8 you're talking about, that speaks in the terms of when there are no sales or purchases of brine qualifying for use of this section, and it says under subsection A, again, as I view that strictly speaks to the current, I'll call it the current operation of brine for the removal of any products that were removed as of 1979. So the bromine, I don't see that applying to additional substances that are extracted. And I guess guide me through where I'm wrong there.
I'm going to tell you, you'd lose that lawsuit because the whatever consideration, whatever royalty is paid has to be multiplied by 8 because that participant is participating in getting the exact same brine, which is now worth more because it has lithium in it. And you have to multiply it by 8. You can't say to the participant, well, you get 8 times the bromine, but what are we going to do about the lithium? He paid for those wells.
Aren't we talking apples and oranges though? Because as a standard, we're going to pay an acreage rate because we can't value what's out there. But then real quick, would we not, I mean, it would almost work as a second option to participate in the way I view it. You participated in this. Now we have a new substance. It's a completely new start for this purpose.
No, it's not because the brine leases lease the brine and all of its constituent parts. They're under lease.
Okay.
But they have to be paid. And the participant, we're only talking about a few participants right now.
Sure.
But we're talking about whether it's binding or whether it's just because we're going to do it. We're talking about setting a precedent that is likely to be applied for this future development. And Commissioner Walford is absolutely correct. You're going to have individuals who can afford it or can find the financing who are going to elect that participation option, demand, and then sue successfully for 8 times the total royalty. That's going to happen. That's enough to scare me out of Arkansas if I'm a company.
Well, I think it comes back to whether, to me, and we can agree to disagree, but my view of it is whether this additional substance to be extracted is included within that essentially definition of brine in that paragraph. And I feel like when you get down to C1, it removes that from what's considered as brine, because again, it's essentially recognizing that would be a new product.
No, because you have to value the brine. You're valuing the brine, which is now worth more, but it's the brine. The brine is the mineral. The brine is the only mineral. That's what the statute says.
But you don't value that for more and less than until you extract that additional substance, correct? Which the Act splits out as valuing on its own separately and apart from the brine.
No, it doesn't. I'm sorry. It
Okay.
doesn't. It causes the brine to be worth more, but you're still paying royalty on the brine. Otherwise, we'd be in here saying, well, we're going to produce this brine and only take lithium out of it so we don't have to pay the $65. But we're not going to say that because I don't believe that's the law either.
Okay. Thank you for your comments.
Any other commissioners? I almost hesitate to say, I'm going to call the evidentiary part of the record to a close. Okay. Before the commission starts its deliberations, I mean, theoretically, what we normally and typically do is I close the evidentiary record down and I ask for a motion, but I'm fairly confident you're going to have deliberations. Mr. Chairman, is this a good time to break for lunch?
Yes.
All right. So why don't we go ahead, go off the record. We will reconvene in an hour. All right. And we'll start deliberations and hopefully have a decision soon. All right, we're off the record. All right, folks, excuse me, could you please take your seats again? All right, we are back on the record. I had called the evidentiary part of the record to a close. At this point in time, I am going to go ahead and just kind of set the table for the commission. Typically, when this matter is ready for adjudication, I just turn it over or ask for a motion or a vote. But I am going to guess that the commission may want to deliberate amongst themselves a little bit before I actually ask for a motion or a vote. I will let the commission know, gentlemen, you probably have three options at this point. You can grant the application, the co-applicant's application as submitted. You can deny the application as submitted, but looking at Commission Rule A2K, the commission can also adopt a motion approving an application as applied for or amended by either the applicant or a commissioner when a quorum was present and 5 commissioners vote to approve the application. Now, my guess is that Mr. Daly and the co-applicants, Mr. Honey, Ms. Clegg, are not going to make a motion to amend their application. I think they've made that clear. So if you do want to amend the application, that's going to have to come from a commissioner. So with that, Mr. Chairman, I'll go ahead and turn it over to you if you would like to do deliberations, or I can do them. What's the prerogative of the chair?
Let's talk about.
All right. So commissioners, do you want, I don't know if anybody wants to make a motion at this juncture and then you can have discussion, or if you just want to have some deliberation or discussion. What's the prerogative of the commission? What would you like to do? All right, discussion. You want to start that discussion, Commissioner?
Yeah, just to come to the point, from my standpoint, I do not believe that the royalty as proposed is fair and equitable. The way I arrive at that is multifaceted. One is that the base case upon which they derive the royalty, they have locked the time in 2007. Since that time, there's been a PPI index increase in lieu of royalty, which would increase that in lieu of royalty by about 1.58 times, which would, rather than a 1.82 royalty, would result in a 2.87. Further, in their testimony, they provided testimony of several other similarly situated countries to the U.S., large OECD countries that, give or take on average, had a royalty in the 2.5% range. So internally within their testimony, there are higher royalties that were expressed than were being applied for. Finally, at one point in their presentation, they indicated that overall this royalty would be the 1.82 plus the in lieu of equated to essentially a 2.5% royalty. Since owners within existing units are already receiving the in lieu of royalty, that is kind of an erroneous calculation there. I believe that the director, when he made his presentation earlier, in deriving a volumetric share, came up with about a 2.35% royalty. Bottom line is all these are higher because we're working with small numbers. Those are large percentage differences between the royalties as applied for. The one last piece is the 8 times calculation, which we discussed at length towards the end of the presentations. Number one, if we are about to move into that season where there could be a legislative fix if there was need of one to fix that. But in light of that, there's a upper limit that I foresee that constrains how high the royalty can go. And so I find that a little bit problematic in trying to determine a royalty that is most beneficial to a royalty or mineral owner. So those are my thoughts.
Any other commissioners that would like to weigh in on the deliberations or the discussion?
What a day. Gentlemen, we feel like we hadn't had enough information, so I'm gonna make a motion to deny the application. Do I have a second?
All right, the chair has made a motion to deny the application. Is there a second? Commissioner Wolford has seconded. Is there any other discussion from the commission? Commissioner?
Well, I'll just add to what Commissioner Walford said. He and I are in agreement. I don't think that a fair and equitable amount of payment has been shown. I have a little bit different reflection than he does. I'll go back to it. I think he referred to Director Bingle's comments when he was speaking. I'll refer to that as well. I know Director Bingle agreed that the makeup, I'll use that, science is not my strong point, but of lithium carbonate, that he thought that it was appropriately the 18.8%. I still struggle with the fact of I don't think it's an apples to apples comparison because we don't have the overall value of that complete unit that's being sold. And so I don't think you can just compare it based upon a volume when the balance of the volume may not have the same value. Secondly, and I think this, I mean, and I would tell y'all where I go in my mind, and it may differ from some of the other commissioners, is Director Bingle said, and I wrote down that, if I can find my notes here, that 12.5% had always been the standard. But we had to look at volumetrics. That was his statement. To me, again, and I mentioned some of this in my previous comments, I think that's the easy route from a standpoint of 12.5%. You could take those operating expenses away to get to that final marketable product. However, I realized that if you did that, there becomes a lot of complications with agreeing to what those deductions are. So I state that just from my standpoint. I think it's got to be lower than 12.5%, but I think it's certainly higher than what's been proposed. And I'll end with that.
Commissioner Russell?
Thank you. I think that both parties, and listen to all the evidence, this is just my opinion, should try to work with the benchmark of about 2.5% royalty on the finished LCE product. That's in my opinion.
Any other commissioners? Any other discussion? So the motion was to deny the application. There was a second. Show of hands, all in favor? Motion passes 8 votes to none. If there are no further questions or comments, wait a minute, do we need to get some in terms of, just pick. If staff gonna reduce this one to writing? Do you know that?
It's easy.
Yes, sir.
I believe pursuant to the rules, we have to provide the order, get it finalized within 30 days. So
Okay.
Unless you direct otherwise, we will prepare the order.
Right. If you would be so kind as to do that, I know the commission would appreciate that.
Yes.
All right. Any other questions or comments? If not, I will call this hearing to a close. Thank you all very much.